Good evening, and welcome to this edition of Labor Vision. I'm Bob Delaney, Executive Director of the Institute for Labor Studies and Research. Labor Vision, a production of the Institute, focuses on topics of importance and interest to working Rhode Islanders. We hope you enjoy this evening's edition.
There really is a lot of gray in these areas. A lot of times, and we've all experienced this in our careers, it really depends on what arbitrator you draw, how they want the case to come out. Some folks are result-oriented, and that includes judges. And Judge Gallo in that case urged the parties to sit down and mediate and negotiate. And fortunately, we did that, and the jobs were saved, and the contract was renegotiated, and the NEA is still there, and everything's going smoothly now. But who knows how that would have come out? We did have a provision in the East Greenwich School contract that allowed the committee to subcontract under some very, very limited circumstances. So I think that would have been the difference in that case, is that there wasn't an outright prohibition. But the argument about others performing bargaining unit work was a consideration. Want me to wrap it up? I'll give you one more example. I wanted to talk about some teacher cases. There is a decision by Judge Savage involving promotion of department heads in Central Falls. I would urge you to read that. It's a 2008 decision. It is about 45 pages long, and it really goes through the whole history of this whole topic with excellent citations. So I leave that to you. One last case I want to share with you. And this is East Providence. A number of years ago, a new chief was hired, chief of police in East Providence. And in its entire history in East Providence, the police chief had always come from within the ranks of the East Providence police officers. And there was a provision in that CBA that prohibited the city from hiring outside the ranks of the East Providence Police Department. That provision was ignored, and the city went out on a search for a chief outside of that department. When I filed an injunction request with Judge Silverstein to prevent the arbitration of that issue, he denied it, and I argued the non-delegable. There was a charter provision that vested the city manager exclusively with the authority to hire, promote, discipline the chief of police. Judge Silverstein kind of overlooked that and said, I want to see how it plays out in the arbitration process. So we tried that over a number of days, and I made the same arguments. And in that case, the arbitrator ruled that the parties could not bargain away that right. Despite what the contract says, despite the history, there's a charter provision that vests exclusive authority in the mayor to hire, select, promote, discipline the chief of police. And then he went on to say, even if I found that wasn't the case, I don't think that they would have prevailed on the merits anyway. So, thank you.
Thank you, Donald. Tea time, you're still playing 18.
Okay. Let me begin, first of all, by saying that I'm a proud public employee. I went to work for my city in 1972, left to join the United States Army and worked for my Army, came back to work for my city, and have been working for my union since 1983. So I stand before you, and with all due respect to my brother to my left, my brothers to my right, tell you as a proud public employee, all of these changes in the spectrum of labor relations and the authority of an arbitrator are geared towards the demise of public employees and public employee unions. But I will also tell you that those of us who have the honor of representing public employees need to bear some of that responsibility. So I begin with the spirit that Professor O'Brien mentioned at the onset. There's an awful lot of middle ground out there. Talk. Don't allow the lawyers to treat our disputes as if we live in a pure world of academia. We don't. And those resolutions we can bring about ourselves as labor relations professionals will best suit our membership and the employers that some of you guys with black hats represent. Now, I say that because John and Lynette are handling a very complex case, and that truly will gather national attention and redefine Article 1 of the Constitution and the right to impair contract. But there are those cases, and that's why my hat goes off to my brother at the right, which are true game changers. And having one winner and having one loser equals two losers. So I would like to think in Providence, those of us who hail from Providence, we would rather labor than lawyer. And we got to see if it works, because as Joe said, there's a long road to hoe, and we won't have the I's dotted and the T's crossed on the Providence case dealing with both the retirement system and retiree health care until winter time. The pendulum has shifted. In Rhode Island, our statutory scheme dealing with labor arbitration and the role of the judiciary has its beginnings in the mid-50s, and you'll all find that in Title 28, Chapter 9. And that was the then legislators' attempt to codify some of the actions that occurred on the federal level with the Labor Management Relations Act, and to empower the parties to contract for a private forum for dispute resolution. Our courts adopted the legislators' public policy, and you'll see those statutes articulated and following the actions of the federal courts in the trilogy as the doctrine of judicial deferral to arbitration was the law of the land in Rhode Island from the late 60s through the late 80s, where we had decision after decision that followed the trilogy in determining what is arbitrable, and that if a contract did not say it's not arbitrable, then it was arbitrable, and that deferral to the reader, the party's chosen reader of the contract, meant that the courts would not review whether there was a mistaken fact, a misinterpretation of the agreement, or a mistaken law, that the parties bargained, demanded that fidelity go to the arbitrator. We had case law in Rhode Island, and get this, the Providence teachers case in 1971 that said a municipality and a school committee cannot argue that an arbitrator exceeded his authority in causing an appropriation not included in a budget, because government can never argue the inability to pay because it has the ability to tax. And that was reaffirmed in the McGovern case, again involving Providence teachers in 1975. As all of these cases were reaffirming the doctrine of judicial deferral, the doctrine of non-delegable authority, and the challenge that asserting the court's authority to review statute and public policy in favor of arbitration violated public policy, was also in the forefront. And one of the initial cases of following the enactment of public employees' rights to bargain in the late 1960s a case that grew out of the Firefighters Act. The city of Warwick challenged as unconstitutional an award of a contract arbitration panel, suggesting to initially the trial court and then the Supreme Court that the arbitration panel has been given by the legislature unconstitutional prerogatives in violation of Article 2 of the Rhode Island Constitution, because by putting in place a collective bargaining agreement between the firefighters and the city of Warwick for those issues that were not agreed to at the table, the arbitration panel has usurpated the authority of the legislature to create a municipal budget. That case was joined by the then Attorney General, the Republican Attorney General of the state of Rhode Island. It was interesting to see that that Republican Attorney General and that Democratic mayor in the city of Warwick, who both thought that the Firefighters Arbitration Act was unconstitutional, would 2 years later face off in a race for governor. Superior Court agreed with the city. The Superior Court said that the arbitration panel was unconstitutionally authorized to foster and promote and publish a collective bargaining agreement which caused an appropriation of money. That case went to the Rhode Island Supreme Court, and the Rhode Island Supreme Court declared that an arbitration panel comprised pursuant to state statute was a public body acting for the legislature and therefore was constitutionally created. Similarly, in the dissent decision to the Jacinto versus Egan case, Justice Weisberger, joined by Justice Doris, spoke about the difference between private sector labor arbitration, in which deferral to a labor arbitrator is more than permissible. It is, again, the party's chosen forum, and the courts should not be enmeshed in labor relations. But when it comes to public employees, the courts should not sit by idly while arbitrators fashion relief that infringes upon public policy and makes declarations of law that may be inconsistent with Rhode Island statute. Bad facts make bad law. And the recent vintage of cases that Matt referred to, beginning with the Vouse case and dealing with a non-delegable authority of the Director of Communications, the Director of Corrections, excuse me, has its genesis in the fact that the state of Rhode Island and its Department of Corrections was found in contempt of court of a federal court order dealing with cruel and unusual punishment and the manner in which the prison was being operated and prisoners were being cared for. As the then Director of Corrections attempted to deal with prison overcrowding and spread out the prison population by bringing about additional buildings, putting additional buildings online, the issue concerning mandatory overtime became a dispute. In dealing with that case, both with the authority of the Director of Corrections and with the authority of the arbitrator to interpret and apply the parties' collective bargaining agreement, both the Superior Court Justice and the Supreme Court looked to a prohibition of Rhode Island to cure itself from a contempt finding by the United States District Court in regards to prison overpopulation and the manner in which prisoners were being cared for. And the court said a collective bargaining agreement cannot be the cause for the state remaining in contempt. Other cases that then followed also, I believe, were directly influenced by some difficult facts. One of the cases was a case I had, known as the State of Rhode Island versus the Rhode Island Laborers District Council, in dealing with the termination of the chief clerk of the 5th Division District Court. This was the first disciplinary case to arise between the Rhode Island judiciary and its employees who had recently organized. The clerk of the 5th Division District Court was terminated by the new chief judge of the Rhode Island District Court, Chief DeRobio, for insubordination on not one matter, but 5 separate matters. Case went to arbitration. And after considering all of the facts, the arbitrator said there was sufficient cause to discipline the clerk who was terminated. That the facts clearly established that the clerk was insubordinate, not on a single occasion, but on 5 separate occasions. But that in light of this court clerk's entire career, those 5 acts of insubordination all took place in a very abbreviated point in time during a period of time in which the court clerk was going through a period of personal turmoil dealing with the death of his father. And therefore, the arbitrator, in exercising his authority under the collective bargaining agreement to determine if just cause existed for termination, ruled that there was sufficient cause for discipline, but not just cause for termination, and reduced the termination to a 6-month suspension, ordered reinstatement, and all back pay other than the 6 months suspension. The court now reviews a decision of an arbitrator asserting the authority of one of its chief judges for the first time. For the first time. And the court said that the arbitrator exceeded his authority and reached an absurd result by determining that there was cause for discipline and then substituting the arbitrator's discretion for that of the chief judge of the district court. And in so doing, sought to curtail non-delegable authorities placed in appointing authorities. The Supreme Court sustained the ruling of the trial court. I would suggest to you that bad facts make bad law. That case arose because of 5 blatant, in-your-face acts of insubordination. I will also tell you, as the pendulum swings from complete deferral to arbitration to a more active role of the judiciary in reviewing actions of arbitrators, the legislature has said it is this branch of government who establishes law and Rhode Island public policy. Following the district court case in which the Supreme Court curtailed the authority of an arbitrator to substitute his or her judgment for management, the Rhode Island General Assembly enacted a specific statute that said the arbitrator shall, unless agreed to differently in the parties' collective bargaining agreement, have the authority to modify all acts of discipline. Similarly, in a case that then followed dealing with the court reporters, bad facts make bad law. Justice Murray, writing for the Rhode Island Supreme Court, declared that unless a collective bargaining agreement includes a past practice provision, a past practice is unenforceable, and labor arbitration cannot create a contract right out of the parties' practice. Well, we all learned that if a past practice was codified, it's not a past practice, and that unless the parties' agreement contained a zipper clause saying there are no past practices, then practices which have been known to the parties, acquiesced to the parties, acted in concert by the parties, are enforceable. That case dealing with free parking to court reporters during a period of a severe parking shortage in downtown Providence, in which an increased portion of the judiciary's budget was being used for free employee parking, caused a different result, in my opinion. The legislature also came back 10 years later to address past practices and to say that past practices that properly exist and meet the 4 criterion are enforceable, but are also terminable by either party with appropriate notice. In response to the Vos decision, not all things can be argued as being a non-delegable breach. And I would like to point to a decision that was rendered by Associate Justice Silverstein, the same guy who handled the East Providence case, before Central Falls went into bankruptcy. And it's the City of Central Falls versus ASME Council 94, 2003 case, and I have a Westlaw site, 22048737. And in this case, Justice Silverstein rejected the municipality's argument that interpreting a party's collective bargaining agreement, the arbitrator exceeded the scope of his authority by prohibiting the subcontracting of certain bargaining unit work, resulting in an impermissible and illegal restraint on the legislative mandate of the administrative authority of the mayor. The Superior Court held, this court does not believe that the application of Vos to be so broad. The court and Vos did not intend its ruling to apply every time statutory authority of a municipality is implicated in some wanton way. Instead, the Vos court made void only provisions encompassing powers inherent and vital to the safe operation of a correctional facility, facility that was in contempt of a federal court order. To allow the city to disoblige its contract duties would be unjust. The city is essentially asking this court to void the contract due to fiscal crisis. This court sees no reason why the city's economic interest in balancing its budget should trump the economic interest of enforcing contracts and the sanctity of contract law. It would make many of the city's contracts simply illusory.
I handled that case, and I wonder what would have happened if Judge Procaccini had reviewed the petition to vacate the arbitrator's award.
A vastly different result, and that leads me to my conclusion. I used to think, as a public employee, labor representative, that this right-wing conspiracy exists day in and day out, and that all of the ills of Rhode Island society may be found at the desk of Republican governors. The older I get, I come to the conclusion that those folks who wear black robes, they're subject to the shifts in the wind just like we are. They're subject to the change in society's norms just like we are. Judge Procaccini's a great drummer and a rock and roll band and a fine individual. And his heritage is found in being a town solicitor for a number of small towns. And that's what he brings to the bench. And there's nothing wrong with it, because it's every element of our society that makes our society as a whole. I warn those of you who are practitioners that Judge Silverstein's enlightened holding in the Central Falls case and Judge Procaccini's misspent youth and the Cranston Crossing God case, neither of those cases constitute law of the case. When the Procaccini decision went to the Rhode Island Supreme Court, the Rhode Island Supreme Court ruled that the entire case was moot because the Rhode Island State Labor Relations Board had found the city to be an unfair labor practitioner by refusing to bargain with the certified bargaining representative and by subcontracting the bargaining unit work. So we never got an answer to that real good academic case and all of the points that Matt spoke to in regards to management rights. Thank you.
I wish to thank the panel for their I wish to thank the panel for their very colorful colloquies today.
Good evening and welcome to our 7th session looking at the history of the labor movement, not only nationally but here in Rhode Island as well. This is being brought to you by Labor Vision, and my name is Scott Malloy. I'm a professor at the Schmidt Labor Research Center at your flagship state university down in Kingston, where we give out a master's degree in labor, industrial, and personnel relations. So we hope you're enjoying this. I think way back at session 1, I had mentioned that I teach this 14 weeks in a semester, which encompasses 28 classes, 2 of them each week, and I thought this would be a much more abbreviated version, but once I get into the details, it's awful hard to leave them behind. So I hope they add to your enjoyment of learning about history and don't burden you down. At least you don't have to take an exam at the end of this. Last time we were looking at the Knights of Labor, certainly the most important labor organization in all of 19th century America. At one point they had 2.5 million members, more than had ever joined a labor union before up to that time in American history, and they had tried all types of highly unusual, dramatic methods in order to bring people into their ranks, and they did very well. And a lot of that was through the using strikes. They were strike happy, there's no doubt about it. And yet, ironically, the leader of the Knights of Labor, the Grand Master Workman, and as I've said before, boy, you could do a lot worse in life than have that as your title. But Terence Powderly, the former mayor of Scranton, Pennsylvania, now the head of the Knights of Labor, was a very conservative guy in many ways, despite being the head of a rather uproarious and radical labor organization. And he kind of caught the irony of it somewhere during his career when he said, just think of it. Opposing strikes and always striking, battling with my pen in the leading journals and magazines of the day for the great things we are educating people about, and fighting with might and main for the little things. So in a lot of ways, Terence Powderly, the head of these, as I mentioned earlier, the horny-fisted sons and daughters of toil, they wanted to, quite frankly, rock and roll. And Terence Powderly was much more conservative in his approach to labor management relations. And somehow or other, they both managed to coalesce together. I mentioned that not only nationally, but here in Rhode Island, some very unusual accomplishments had been achieved. For example, a daycare center in Olneyville, highly unusual in the 19th century, or even most of the 20th century. But one of the things that the Knights was instrumental in bringing about, even though the people that helped make it happen were doing it for dubious reasons, was in 1888. the Rhode Island Constitution was amended by the Bourne Amendment. Augustus Bourne was a Bristol representative to the General Assembly. And for years, going back to the 1830s and 40s, before there was a Republican Party, they were called the Whigs, they were called the Law and Order Party, they had kept the vote from immigrants, which in those days meant primarily and almost exclusively the Irish. The Yankees who ran the state wanted no competition from their distant cousins from the British Isles. But what had happened over the years, as time passed, as generations slipped away, more and more of the Irish who had immigrated here were having children who were born in Rhode Island and were American citizens. They were no longer immigrants and no longer able to be exploited the way their parents and grandparents had to suffer. And so in 1888, the Republican Party, and this is a very a Machiavellian movement, if you will, they decided to eliminate all the barriers, or most of the barriers, to immigrant voting. Was it they had simply fallen in love with the Irish brogue after all those years? Hardly. The fact was an entire new wave of people. They called them the new immigrants, particularly from the Mediterranean, as well as Jews from Poland and Russia, were beginning to come into Rhode Island as early as the 1880s, but particularly the 1890s, right down through the advent of World War I in 1914, when all immigration was cut off due to the war. But they passed this Bourne Amendment, and by doing so, the Republican Party understood that they in some ways were enfranchising the Irish, but there was nothing they could do about it because now they were American citizens anyway. They wanted to be the champions of the new immigrant into Rhode Island, the Italians, the Greeks, the Lithuanians, the Poles, the Jews, all sorts of people from Southern and Eastern Europe. And for a while, they were able to take advantage, I suppose, of the newer immigrants, much to the chagrin of the Irish who had been here for a long time, but who had made up the backbone of the labor movement. The Knights of Labor were also very successful in the state, and they had some strong allies in the General Assembly. People like Dr. Lucius Garvin was the representative from Cumberland. He was a pediatrician who was often rumored that he delivered every voter in Cumberland history. For years and years, he had brought kids into this life of ours, and they later repaid him by voting him time and time, not only to the General Assembly, but after the great streetcar strike of 1902 in Pawtucket, Lucius Garvin was elected governor as a labor candidate. But that's in the future. We don't want to get too far ahead of ourselves. But Garvin, while he was a state rep, also introduced all types of legislation to help ordinary working people. And one of the things he did was health and safety. And it's hard for us to imagine a time and place where this wasn't the way of the world. He passed a law which mandated that factories and manufacturing plants had to have stairways outside of the building, fire escapes, if you will, so that in case of some sort of conflagration, people could get out alive. This was due to the Knights of Labor and Lucius Garvin getting together politically to do all of those things. Now, as you might guess, anytime there's an action, there's always a reaction in life, or it always seems that way anyway. And the captains of industry, or the robber barons, depending on your own point of view, weren't going to sit around, particularly people like Jay Gould or Joe Bannigan, and get lectured to or be pushed around by the rank and file. And so they slowly but surely organized their own groups to fight back. And by 1886, 1887, when the Knights had reached their apogee, so to speak, things began to change. And the discrediting began particularly in the major newspapers of the time. The New York Sun, one of the leading editorial lights in the Gilded Age, had this to say in 1886. 5 men in this country, the executive board of the Knights of Labor, 5 men in this country control the chief interests of 500,000 working men and can at any moment take the means of livelihood from 2.5 million souls. They can stay the nimble touch of almost every telegraph operator, can shut up most of the mills and factories, and can disable the railroads. They can array labor against capital for quiet and stubborn self-protection or for angry, organized assault as they will. Labor had become a special interest as soon as they flexed their muscles. And even though they had been pushed around for decades and generations, you never heard a peep out of most of those newspapers when that was happening. When working people began to fight back, suddenly there was something to be afraid of. I wanted to give you another quote, and I do a lot of this in my class because I think it makes the moment in time come alive when you hear what actual participants had to say. And you can't really understand the Knights without having an appreciation of just how idealistic they were. And looking back on it as a trade unionist myself, they may have been a little too idealistic because sometimes you want to be practical. You never want to kill the goose that laid the golden egg. And so listen to this quotation from a flyer that the railroad workers on Jay Gould's system passed out to their fellow members. It said, "Tell the world that men of the Gould Southwest system are on strike." This is a second strike. "We strike for justice to ourselves and our fellow men everywhere. 14,000 men are out. Bring in all your grievances in a bundle at once and come out to a man and stay out until they are all settled to your entire satisfaction. Let us demand our rights and compel the exploiters to accede to our demands." Boy, that's militant and unambiguous language. But I have to say, as a former labor leader myself, the last thing you'd probably want is to say to your membership, listen, everybody walk out and make a list of every grievance from A to Z that you've got, and don't go back to work until they're all perfectly settled. Well, maybe that might happen in heaven, but it's not going to happen in this world as long as we're alive. Nothing ever gets done to anyone's entire satisfaction. That's why we have collective bargaining. That's why both sides, labor and management, sit at opposite ends of the table and try to work out some type of compromise settlement where both sides can walk away and say, well, we both got a little something, we both gave up a little something, and that's just the nature of labor management relations. But when you tell people not to go back until they're 100% satisfied, I've never met an American yet who's 100% satisfied about anything, particularly working conditions. So the Knights went on their merry way, and they did all kinds of unusual things, not only in Rhode Island, as I've mentioned, but they organized quarry workers in Vermont. They organized shoe workers in Maine, in Massachusetts, which was the largest state to have so many Knights of Labor. They organized virtually everyone who walked the face of the earth there. So the Knights were very involved, not only in organizing, but they got into third-party politics. And where they were active in that area, they were very successful as well. So the Knights tried to used that open window of opportunity that appeared in the middle of the 1880s during the Gilded Age to turn the world upside down. The problem was, and Rob Ware, who's a friend of mine up in Massachusetts, has written 4 or 5 books about the Knights of Labor. And it's tough to write one book about them because they were all over the place and nobody can seem to do it. They have to take a particular instance of it. The Knights, in Rob Ware's words, were shot back to work because once management got its act together, once they understood the modus operandi, how the labor movement, how the Knights operated, there were certain things that stood out that after a while you could almost expect to happen and prepare for it. And they did this all around the country. And in Rhode Island, and boy, is this a real beautiful piece of history here, even though I don't agree with it, management formed what was known as the Slaters Club, named after Sam Slater, who operated the first mill in America on the banks of the Blackstone River back in 1790. They formed an organization called the Slaters Club. And they pooled their resources, not only money, manpower, political influence, everything they could. And so the Knights of Labor in Rhode Island and management in the Ocean State, just like in all the other places that the Knights were active, kind of went to battle for life or death. And strangely enough, because we don't really know a lot about this strike, the moment the opportunity came at a place called the Morse Manufacturing Company in Westerly. A lot of people then and now don't even know where Westerly is or how to get there or much about it, but it was a thriving place for industry. And after about a year in which both sides threw everything they had into this conflict, the Knights of Labor went down. And it's probably not surprising, simply because management could array so much power and treasure on its size. And so throughout the nation, in those final years, things began to fall apart for the Knights of Labor by 1887, 1888. By 1890, they were pretty much a memory, but again, they would set the stage for the next group after them. But I just want to go over a few last things with the Knights because they were such an astounding and unusual organization in that era. They believed in broad-based unionism. That is, they took in the skilled, whether it was a bricklayer or a machinist. They also took in the unskilled, whether it was people that just mixed rubber or maybe carried cement around. They took everyone in, and that wasn't always the case in the labor movement in America. And by the way, they did last, I think the last local was in 1949, the Boston Motion Picture Operators. Boy, that's quite a piece of history there. But in their legacy, they left behind all sorts of cultural things that would be important to the labor movement later on. They were very, very big into singing, into glee clubs, into orchestras. They were much like some of the Germans within their ranks. They really loved the musical side of it. They put on their own plays at times, and they tried to entertain their people in the labor way, not by the ways of management. And they came out, and I'm sure all of you have seen this on the news in the last 4 or 5 months. We've seen the Occupy Rhode Island movement, and that was spread around the nation. The Knights of Labor had as their theme song 99 plus 1. And the gist of that song was that 99% of the population worked to support the splendor of the 1%. This is over 125 years ago. Some things are not new, even though they may seem that way. And they had a wonderful song called Storm the Fort. They always had these very strong verbs. And the song went, toiling millions now are waking. See them marching on. All the tyrants now are shaking, ere their power is gone. And the chorus was, storm the fort, ye knights of labor, battle for your cause, equal rights for every neighbor, down with tyrant laws. Well, I think we ought to resurrect that. It's got a nice ring to it, and we should get some people singing it. Sadly, the American Federation of Labor, which came after the Knights in the 1890s, although they were very successful in a different way, they changed the name of that song from Storm the Fort to Hold the Fort. Now, boy, I'll tell you, the difference in that verbiage is all in the world. I also came across, the Knights of Labor have a repository of their material, thanks to Terence Powderly when he left the Knights around 1890. He went to work for the government, and he was in Washington, D.C., working in immigration. And he had all the letters, the manuscripts, the reports, the papers, the minutes of the Knights of Labor, and he donated them to Catholic University, the largest repository of labor material in the world up until then. It's so big that to look at it, a number of colleges have purchased microfilm of all of those materials. The closest one is University of Massachusetts in Amherst. They have 125 rolls of microfilm. Unfortunately, it's not that well indexed, and you could spend probably the rest of your life looking through the Knights of Labor material. But I found this little jingle, a poem that was written by a woman in 1887, and again, the Knights were very open-minded about that. And this poem is so modern, it's almost hard to believe. This unnamed young woman wrote in and said, they talk about a woman's sphere as though it had a limit. There's not a place in earth or heaven. There's not a task of mankind given. There's not a blessing or a woe. There's not a life or death or birth that has a feather's weight of worth without a woman in it. And boy, I'll tell you, Gloria Steinem could repeat that today, and I don't think they would have any problems with that. The Knights also had some material culture. They were into putting out pins. They were really the first union to put the pins out. And in my collection, I've got a couple of Knights of Labor dues pins, one of them from the longshoremen in Boston who were part of the Knights. They also put out, I'm sure to the consternation of Terence Powderly, beer mugs. And so if you come to my house and you like to have your beer in an original Knights of Labor mug, I can do it. In fact, I can fill 5 or 6 of them up for you. They had their own trade cards in which they advertised their wares as being union-made. They emphasized leisure activities. They were into sports on the local level and the national level. And in fact, even in their death throw in 1890, they were the first group to organize the baseball players into a national union. And the guy who did it played for the Providence Grays right here in Rhode Island and went on to run that union. And we're going to be looking more into that because I think there's some real possibilities to have there. The Knights used to like to put on lyceums where people would debate the issues of the day. They loved their parades. And in 1893, at the Chicago World's Fair, they were the only union among all of these businesses to set up a display to really, in a way, show the world what their members could do. And so they remained to the very bitter end a highly unusual, dynamic, dramatic, unpredictable organizer of the rank and file of the Gilded Age in a way that in some ways has never been duplicated. The air favelas we'll learn about next time was more into organizing just skilled workers, which limited the numbers of people that they could put into the union, whereas the Knights had the welcome mat out for just about everyone. And so even though they went down, and we've seen a number of union groups go down for the long count going back to the 1830s, we're like the Egyptian phoenix. We rise from the ashes of the old. We may try a different wrinkle, a different approach, but we always learn from those who came from before us. And we try to avoid their mistakes and reintroduce their successes. So I hope you've had a good appreciation of the noble and holy order of the Knights of Labor, because there's no doubt in my mind all of those members did go to heaven because of that wonderful name. And so next time we're going to take a look at Sam Gompers, probably the only greater personality in 19th century labor than Terence Powderly. He was an English immigrant. He was a petite guy. He was about 5 feet tall. And how he ever became the leader of the horny-fisted sons and daughters of toil, we'll never know. But he was a great orator, as many of these labor people were in those days. So again, this is Labor Vision. This has been the latest installment, and you'll look at labor history in the United States and here in Rhode Island. And I hope we haven't bored you to death, and you'll be getting your grades very soon, but you have to stay tuned. So we'll look forward to seeing you next time, and thank you very much.
Thank you for joining us for this edition of Labor Vision. We appreciate your input and encourage your comments. Labor Vision can be seen 3 times each week: Tuesdays at 7 p.m., Thursdays at 8 p.m., and Saturdays at 5 p.m.